Hello guys, how are you? Today I want to explain about avoid prostitution and criminal. Discussion of the avoid and the right to sue in the law has been determined with regard to the right of prostitution only available to the public prosecutor, and namely the prosecutor who authorized by law number 8 of 1981 concerning criminal procedure code article 13 and 40 at general court environment and auditor based on article 70 of the law number 1 draft in 1958 in military court environment. The definition of procedure has been authentically determined or formulated in article paragraph 7 and of the criminal procedure code, which read prosecution is act of public prosecutor to delegate cases criminal case to complete district court in the term of according the method regulated in the law with a request to be examined determined by judges in court. The person is charged in a proceeding is a public prosecutor as defined in Article 13, paragraph 6 of the Criminal Procedure Code, which basically read: the public prosecutor is prosecutor who is authorized by this law prosecute and carry out the determination of the judges. Basically, a preparation of criminal act in a broad sense must be processed before the criminal court. However, both in general and specifically, the law determines the habilitation and of the elimination prosecution. And there are certain cases talking about the habilitation of prosecution is turned off. There is also specifically regulate outside of the chapter 8 book 1 of criminal code. Prosecution among other content in article of 483, 484, Junto 61 and 62 of the criminal code regarding press of sense. Article 166 and 221, paragraph 2, article of complement of sense. If a complaining is not revealed by who has the right of complaint. Article of 4 criminal procedure code junto article 8 of the basic law, the Attorney General of office regarding the closing of cases which are principally based on right. Opportunity article 72 KUHPM, which in principal content the principal authority 164 KUHPM. The reason for the loss of the right to sue both the criminal code and outside criminal code of follow. First, ne bis in dim, and article 76 on the criminal code. Date of the occurs, article 77 of the criminal code. Expiration of the right to prosecution, article 78 criminal code. Payment of maximum fine or violation that are punishable by fine, article 82 of the criminal code. Habilitation and amnesty outside the criminal code. First, net bis in idem, article 78 on criminal code. The true meaning of nebis bin in idem, not or not for a second time. There is not a translation of the term. Also we should use it but as verified one for this can be but versi no one for his death can be heard now for a second. In Anglo-Saxon literature, this term translates into one called but with jeopardy for the sum over. And second, that of the defendant, Article 77 of a criminal code, the authority to demand criminal punishment is removed if the defendant die, termination of investigation, or termination of prostitution because of the suspect or death of this accused is natural thing because of their extent. Prosecution must be some who can be held responsible for his death. And three, expiration of right of prostitution. Van Belman said the purpose of his expiration institution is to bring a matter that has been very long. Possible people have forgotten or needed to be tried against. And maybe also that evidence in cases has been lost or clouded by too long, so it can trust anymore. However, he argued in fact expired in delicts that are dangerous in nature or those with status recidivism. So thank you for your attention and goodbye.